Okay, thank you. And what did you, the notification that you got that the caretakers were coming, did they indicate that they were to show up at the time that you heard someone at your door?
No, they were here and gone way before. As I said, they come between, it's a woman, she comes between 8 and 8:30 on Sundays. And that Sunday was no different.
Was there anything else about the knock on the door that indicated who it was? Or, I'm sorry, was there strike that. Was there anything else about the ringing of the doorbell that would indicate who it was?
Yeah, continuously ringing the doorbell. And the height of the person, as I said, I knew it was Kevin. There was no indication that it was anyone other than Kevin.
Have you ever had anyone else come to your door and ring the doorbell? Can you describe how the ringing of the doorbell was?
No, I
Objection relevance.
The doorbell is
overruled.
Old. Just rings.
Okay. Like, was it repeatedly or was it only one time?
Oh, he rang it several times.
And does anyone else who visits ring it in such a fashion?
No.
Okay. Thank you. No further questions.
May this witness be excused?
Your Honor, I just briefly want to ask one more question.
Okay.
Just to be clear, Ms. Clan, you did not see Kevin at the door that day, though.
Objection asked and answered.
Sustained.
I did see him at the door that day. The window's not that dark. The window is very light.
Okay.
Okay.
No further questions.
No further questions by the people.
All right. So this witness is excused.
The witness may be excused by the people.
And
Yes.
by defense.
Okay, ma'am, you're excused. Thank you. The defense may call its next witness.
Your Honor, we don't have any more witnesses, and we rest our case.
All right. So you've had an opportunity to explain to Mr. Clan that he has a right to testify and he's opted not to do that?
Yes, Your Honor. Let me, can I have one moment?
Yes, and it would be my normal practice to ask him that for the record, so there's no confusion later on. That's all I would ask him, basically what I just asked you.
Yes, Your Honor. Your Honor, he doesn't want to testify.
All right, is that right, Mr. Clan? You've had a chance to talk to your lawyer about it and you feel like you don't want to testify?
Yes, my only concern is that the initial court order,
I don't want to talk to you, sir, about the case. I'm just asking you whether or not you want to testify.
I do not want to testify, no.
All right, thank you. All right, the defense is rested. Is there any rebuttal from the people?
No, Your Honor.
All right, so both sides are resting. And are there closing arguments from counsel?
If we may, Your Honor.
Yes, Your Honor.
I don't have a problem with that. All right, we'll begin with the people and then the defense and then the people have a chance for rebuttal.
The defendant is charged with 3 counts of violating a court order in violation of PC 273.6A, count 1, 2, and 3. To prove that the defendant is guilty of these crimes, the people must prove beyond a reasonable doubt that 1, the court issued a written order, that 2, the court order was an emergency protective order issued under Family Code 6240-6275 et sec. 3, the defendant knew of the court order. 4, the defendant had the ability to follow the court order. And 5, the defendant intentionally violated the order. When we're looking at People's Exhibit 1, we can see that it is a court order issued by the court. And on the written order, it states that, among other things, the defendant must not harass, threaten, disturb the peace of Sonia K. and George K. The defendant must not contact directly or indirectly, including but not limited to via telephone. Mr. Kland must stay away 100 yards from the victims in this case, Sonia K. and George K. He must stay 100 yards away from their home on San Ramon Avenue, including there is a move-out order. Also, looking at the emergency protective order, we can see at the bottom that this is issued under Family Code 6240-6275. The people have sufficiently proved elements 1 and 2. What is more at issue is the elements of the 3rd element, the 4th element, and the 5th element. That the defendant knew of the court order. Here we know that Officer Warner, he testified that he explained the EPO, the emergency protective order, to the defendant. He had a long conversation with the defendant about the emergency protective order. Mr. Kland was able to view the protective order. He was facing Officer Warner when Officer Warner put down the emergency protective order. Mr. Kland had an opportunity to pick up the emergency protective order, to read it, to examine it. It is he himself who chose not to do so. Officer Warner testified that Mr. Kland was not so intoxicated that he was unable to understand what was happening. Instead, he was able to explain what was on the protective order, and from the testimony, the defendant knew enough to abide by portions of the protective order. He knew he had to leave. It states on there that there is a move-out order, and Mr. Kland knew that he had to leave. He did so, and he left. And he knew enough that he got a hotel room. He knew enough that he did not come back immediately. And the defendant, and so he has the ability to follow the court order. He did leave. There's nothing that shows that he has to come back. He did not have to come back. He did not have to call Mrs. K or Mrs. K. And that fulfills the 4th element. And then there was no testimony, also in the 4th element, there was no testimony that he is so mentally unstable that he was not able to follow the emergency protective order. In fact, we saw the reverse, how he knew he had to leave, and he did so. As for the fifth element, the defendant intentionally violated the court order. Within the court order, the defendant was instructed not to contact directly or indirectly, including but not limited to telephone calls. On June 14, he called 10 times. On June 15, he called 11 times. On June 16, he called 2 times. This is almost like no one forced him to make these calls. He made the calls via his own personal cell. He was also not to harass, threaten, or disturb the peace of Sonia K. And those 3 things are exactly what he did. He called nearly 30 times in 3 days. That isn't an abnormal amount of times to call someone. I don't even have 30 calls within a month, but Mr. Kland chose to call Mrs. K almost 30 times in 3 days. This is enough to show that he is harassing and disturbing the peace of Mrs. K. There's so many calls that the detective didn't even record the entirety of the last approximately 10 calls because there is just so many. But in all of these calls, from the June 14, 15, and 16, you can clearly tell that it is the defendant because of the content. Mrs. K recognizes his voice, and he even identifies himself by name. Not only does he harass and disturb the peace of Sonia K, which he was not supposed to, he threatens Mrs. K. He calls and states at the voicemail minute 13:02 on June 15, strike that.
If you can reference me to the page in the transcript, that would be helpful.
Okay, yes, I can do that instead. On the second page, line 24, he states, "I'm going to start suing people."
I'm sorry, could I have just a moment? All right, okay, I see where you are.
Okay, yes. On line 24, this is dated June 16, he says, "I'm going to start suing people." Because, and then on the fourth page, on line 16, he again states, "I'm going to sue you, sue the Leonards, sue the clans, law enforcement." Page 5, line 5 to 6. "If you don't let me in the house, I'm going to start suing you and Dad, and probably your brothers." Multiple times, Mr. Kland calls and threatens to sue Mrs. K in direct violation of the court order to not threaten. On top of that, he was to stay away at least 100